Hi and welcome to Know Your Rights. I'm Chris Fisher. This video is part of a personal injury series in association with Curry Law Group. We're going to focus in on the uniqueness of motorcyclists, pedestrians, and being a passenger in a vehicle. And from Curry Law Group today we have Dan King. How are you, sir?
I'm fine, thank you, Chris.
Thank you for being here. All right, let's talk about these unique issues one by one, and we'll start with the difference between an automobile accident and a motorcycle accident.
Very good. You're obviously dealing with injuries, and the unique aspect of motorcycle accidents and pedestrian accidents versus automobile accidents, probably the biggest difference is going to be the nature of the injury. Typically with motorcyclists and pedestrians, you're dealing with car versus a person. So the injuries are usually catastrophic or more serious. You bump a car, and two cars bump at 5 or 10 miles an hour, you may have some injuries. However, when a human body is hit by a car going 5 or 10 miles an hour, the injuries could be catastrophic. So from the get-go, you may have a difference with regard to the injuries.
And also when it comes to insurance, motorcyclists are insured differently by law than somebody in a car, right?
Absolutely. Florida has what they call no-fault insurance. PIP stands for Personal Injury Protection, which basically provides for $10,000 of insurance coverage for a person who has that insurance. There is no requirement for PIP coverage for motorcycles, I'm sorry. In fact, the law in Florida is if you're over 21, you're required to wear a helmet as long as you have $10,000 in medical insurance coverage, not necessarily PIP. So the big difference in automobile and motorcycle is going to be with the PIP coverage.
All right, staying on the topic of motorcycles, you have motorcyclists that are obeying all the speed limits and the laws, but you have plenty of people out there that get in wrecks going way over the speed limit, 100 miles an hour, 130 miles an hour. Assuming they live through that, is there anything that changes there?
Absolutely, because what you're now getting into is in Florida we recognize what's called comparative negligence. What that allows us to do is to apportion liability or fault between parties. So for the example that you use, a motorcycle going 120 miles an hour, and I know we've all seen them, and you're in a car and the motorcycle turns in front of the car, and the car doesn't see him and hits the motorcycle, but the motorcycle is going at a rapid rate of speed, you have issues of fault. You can apportion those faults. So under Florida law, it doesn't necessarily mean that the car is going to be 100% at fault or the motorcycle is going to be 100% at fault. We can apportion that. And if you got a guy going 150 miles an hour on a motorcycle, there's going to be some fault even though the car may have been at fault. So those issues of liability and comparative negligence are going to definitely come into play.
Okay, let's move to being a passenger. Is there a difference between being a passenger in an automobile and on a motorcycle?
Not really, not if you're making a claim, because the passenger does have the opportunity, though, to make a claim not only against the other vehicle that was involved, but they also have the opportunity, if the facts warrant it, to make a claim against the driver.
Let me ask you this, because in that case, a lot of times the driver is going to be a friend or a family member, and I'm sure we've all been through this where, even if not personally, you've seen somebody sue a friend. Do you have to sue a friend, or is there a way around that? Well, what do you do as a lawyer, you know? How do you
those
advise?
Issues arrive, and we have to deal with the client, and we have to do what's in their best interest. And if the at-fault driver is the driver of your car and is your best friend, and he's the one or she's the one who caused your injuries, then we do have to make a claim. That's the reality of the situation. You can call it a claim. You don't have to necessarily say you're suing the driver, but the reality is we are making a claim against the driver. But when I'm representing a passenger who's been injured, I'm going to pursue it aggressively against who's ever responsible, whether it's the driver, whether it's the other car, or whether it's a combination of both.
Okay. Well, let's move on to being a pedestrian and getting hurt in an accident, because this is very interesting. Your automobile accident can actually kick in when you're a pedestrian, right?
That is true, and it's a unique under Florida law. We have what's called PIP, which is Personal Injury Protection, will pay us up to $10,000. If you are a pedestrian walking on the sidewalk and you are hit by a car, even though you're not in your car, your own PIP will provide coverage up to $10,000 in medical expense. Why? Because your PIP coverage provides for injuries related to an automobile accident. You were a pedestrian, A lot of people don't realize that your PIP will pay if you're hit by a car while walking or riding a bike. So,
Is there anything else people need to know if they were on a motorcycle or a passenger or a pedestrian?
well, the liability issues may be different. The biggest difference, again, is going to be the catastrophic nature of the injuries. There's going to be some difference in insurance coverage where PIP will come into play typically when the pedestrian will come into play, certainly with automobile accidents. PIP doesn't necessarily come into play with motorcycle accidents. So there's going to be a variety of factors and different issues, so you got to make sure that you have a lawyer who understands those competing liability interests.
And for those that want to track you down at Curry Law Group, how do they get a hold of you?
You can reach Curry Law Group at 813-653-2500.
Dan King, thank you, sir.
Thank you.